Originally, Article 105, Clause 3 provides that the privileges of the House of Parliament and its members were to be those which were enjoyed by the members of House of Commons in England on January 26, 1950, until defined by the Parliament. The 44th Amendment Act 1978, in a move towards greater separation from its colonial heritage, has amended this article and has omitted completely any reference to the House of Commons in future. New privileges can be defined by law made by Parliament, which it has not yet done. The legislation now states that the privileges are the same as they were before the reference was repealed. It is Taylor's opinion that, quote, all that this change achieves is to make the law slightly more unclear. At present, these other privileges are freedom from arrest. This privilege is well established in England. A member of Parliament cannot be arrested or imprisoned on a civil proceedings within 40 days before and 40 days after the session of Parliament. If a member is arrested within this period, he should be released so that he might be free to attend Parliament. This privilege is available against civil arrest and does not extend to arrest or imprisonment on a criminal charge, or of contempt of court, or to preventive detention. In India also, freedom from arrest has been limited to civil causes and has not been applied to arrests on criminal charges or to preventive detentions. Right to exclude strangers from its proceedings and hold secret sessions. This privilege may be regarded as corollary to the freedom of speech. This right was used in the 18th century mainly to prevent reports being made to outsiders, especially to the king, of the speech made in the House. The Houses of Parliament in India enjoy similar power. However, in modern times, secret sessions are held only in exceptional occasions, because the voters must be kept informed of what their representatives are doing in the legislature. Right to prohibit the publications of its debates. In England, the House of Commons has a right to prohibit the publications of its reports, debates, or other proceedings. In India, in the famous Searchlight case, AIR 1959, the question was whether the publications by a newspaper of those parts of the speech of a member in the House which were ordered to be expunged by the Speaker constituted breach of privilege of the House. The Supreme Court held that the publication of expunged portion of speech constituted a breach of the privilege of the House. Right to regulate the internal proceedings. The House has an exclusive right to regulate its own internal proceedings and to adjudicate upon such matters. Except in case of ordinary crimes, the courts will not interfere in such matters. In the leading case of Bradlaugh versus Gossett, 1884, held that the decision of the House of Commons on matters arising within its precincts could not be controlled by the court. In India, Article 122 expressly provides that the validity of any proceedings shall not be called in question on the ground of any alleged irregularity of procedure. Right to punish members or outsiders for contempt. The House of Commons has power to enforce its privileges and to punish those, whether members or strangers, who infringe them. Each house also has power to punish members or strangers for its contempt. This is one of its privileges. Thus, the House has two powers: one, to punish for the breach of its specific or defined privileges, and the other, to punish for the contempt of the House.